Highland County Common Pleas Court Judge Rocky Koss ruled in favor of the defense Tuesday on a motion to exclude testimony regarding an accelerant-detecting canine in the murder trial proceedings of Wesley Coonrod. Coonrod's attorney William Mooney said the state, represented by the Highland County Prosecutor's Office, intended to use the testimony to indicate accelerant was found at the scene. An investigator from the State Fire Marshal's Office used a canine during his investigation into Coonrod's residence on Lafayette Street in Greenfield. Coonrod's 2 young sons were killed at that residence during a fire in March. Mooney said according to the fire marshal's reports, the canine indicated 5 times that there was accelerant at the scene. Lab tests conducted on samples from the scene did not support the dog's findings, he said.
In the capital case, they're offering that evidence as proof that Wesley put that accelerant there. That's the purpose of that testimony. And we can't cross-examine that. And the literature says it's not valid. And that's the position we would be put in. In a capital case, the star witness, the star scientific testimony is not subject to cross-examination. And in a capital case, we all know that capital cases are different. And as the gatekeeper for that kind of evidence, which we all know is the court, that evidence in this case should not be admitted.
But admissibility is a separate issue that the court, I do not believe, would be abusing its discretion in permitting Mr. Lawless to testify what he used, the tools he used to reach his determination that this fire was intentionally set and that an accelerant may have been used. The only remaining issue then is who said it. And that's still a burden that we have to establish beyond reasonable doubt that Mr. Coonrod set the fire.
He is relying on a dog, and we can't cross-examine a dog. And the purpose of that testimony is directly proportionate to their burden of proof. And it is that important to this case. And they know it, and we know it. And I'm sure the court's aware of it. And we are powerless to combat it if the court allows it in.
But the lab has certain standards that even if they may have found that there may have been some accelerant, if it wasn't enough to get above the standard, they would say it would be negative. Not inconclusive, but negative, because they have an arbitrarily set standard that they use.
I don't know if it's arbitrary. It's accepted in the science community.
No,
it's not arbitrary.
Well, it's still, you could still have some accelerant, and they would report it negative.
I understand.
It falls underneath that standard.
So,
doesn't necessarily mean there wasn't anything there.
What I'm getting at is how do you know that the dog's alert is accurate if there is no test to confirm it? The court takes the same view this time based on the arguments of law that the testimony is not permissible. Pre-trial ruling will be to exclude it. Now, in the event the state has evidence it would like to offer that would validate that the dog was accurate, then I will certainly hear that. It's going to take evidence to convince me that this alert has a place in a court.
Grandy indicated the state would file a motion to reconsider and Koss set that matter for a hearing for 10 a.m. September 27th. Motion to exclude testimony.